I probably don't need a mic, to be honest. Right, so if I can take Kate first. 2 minutes, Kate. 2 minutes, Kate.
Thanks, Chair. This is the first elected disputes committee. It was elected by a ballot of all the membership in March. Under the Constitution, 18E, which spells out its role, it says, the Disputes Committee shall adopt its own procedures and standing orders, subject to approval and amendment from time to time by National Conference. So since it was elected, it has adopted its own procedures and standing orders. They've been subject to approval. The first time they've had to bring them forward to approval is now, so it's a proper process has been followed. In the meantime, of course, the Disputes Committee has had a number of cases to deal with, and they have been operating under their draft standing orders, and the National Council has been informed of that procedure. Within the standing orders there are a range of options which include suspension. As you've heard on a number of occasions, the Disputes Committee have thought it is appropriate to suspend a person for a limited period of time. It's one of a number of options, and I think it's an option that shouldn't be used frequently, but it does say it's for exceptional circumstances, and I think it's an appropriate and proper option for the Disputes Committee to have available to them. Thank you.
Next speaker.
Terry Conway from Islington, speaking against A1 and on the question, and secondly on the question of confidentiality, which has been raised by a number of people. I specifically want to draw conference's attention to the point in A1 about the supposed right of the complainant to question the person bringing the person complained about, to directly question the person complained about. Mike talked about the question of natural justice. I support natural justice. Within the bourgeois legal system, there are provisions in some cases for people not to have the right to question their accuser directly. Do we provide less protection for people who have been abused than the bourgeois courts? I think not, conference. This would be an extremely dangerous situation. Of course, people have the right to know the complaints made against them, but to set up that adversarial situation of having the direct right to question and therefore to potentially intimidate, I'm not saying that anybody would, but that's the potential, to intimidate the person bringing the complaint, is not a road that we want to go down. On the question of confidentiality, I strongly support the Disputes Committee in this point. It's in my role as the Membership and Branches Coordinator, I have the unfortunate pleasure to know some of the cases that have come to disputes, but I don't think conference is in a position, and I don't think some of the people who've said so are in a position to say the basis on which disputes has made decisions.
Ms. Terry. Lesley Mahmood.
Comrades, sorry, please settle down. Thank you.
Lesley Mahmood, Liverpool branch. I just want to speak mainly about this issue about the direct questioning of the complainant and witness. Recently, there was a case of suicide of a woman who had actually cooperated with police, reported a case of alleged rape, cooperated with the police. The CPS decided not to go ahead with the prosecution, not because they didn't necessarily believe her, but because of some problematic evidence and the thing standing up in court. And as we know, only 5% of rape cases are ever successful in court. A tiny minority only ever go to court. And that was one example. her alleged rapist then took out a case which the CPS then backed him in prosecuting her. If you go for direct questioning of your complaint and your witnesses, what you're saying is that person can be subjected to the same abuse. Now, I'm also speaking from personal experience of bullying in a workplace situation backed by my union, where the bully was allowed by the chief executive, who then represented me in a complaint against the chief executive, because my bully was allowed to take out all the F words and poking me back 2 inches away from the face, but call me incompetent, useless at my job, and all the other things that he said, just took out the F words. And that was in effect, I was bullied all over again. And that's what happens when you get that situation. And that's why I completely oppose A1, and I support the other comments that have been made about confidentiality.
Comrades, my name is Brian Green, ex-chair of Norwich branch. I'm the person who was spoken about earlier in the report. I would do exactly the same what I did before. I measure the substance of an organization by one principle and one principle only. Do we put the interest of the class first before our own interest? When I put forward a proposal around July the 10th that Norwich branch should intervene, it was the branch's property, not the secretary's property. This was a political dispute. And we did make the intervention with very good effect. It brought us to the attention of the union movement in Norwich. We were highly appreciated as a result of that intervention, and I was suspended. Why? Because I pointed out the democratic principle that a secretary cannot substitute herself or himself for the branch. They had to circulate that. It was the branch's property. It was to be discussed, and their democratic right consisted of one thing and one thing only. They could append their own comments and their own criticism.
I would like some guidance here, because
no,
we shouldn't really be hearing your case. It seems to me.
No, this is exactly what happened. I used 24-point email to make the point that this person was behaving undemocratically and pointing out what rights they did have. And I was accused of bullying. And it destroyed Norwich branch.